Welcome to Voice of Immigration. This is your host, Jon Velie, CEO of OnlineVisas. The ink is barely dried on the settlement between USCIS and ITServe Alliance following the lawsuits in March, which effectively threw out a number of memorandums that USCIS had made regarding third-party or staffing-type H-1B decisions. But Forbes, Stuart Anderson, has one of the leading columnists on immigration, has written high-skilled immigration restrictions expected soon from Trump in his May 28th article. This comes off the presidential proclamation, which came out about a month ago, a little over a month ago, in which it said in 30 days, a number of the agencies would need to report to him and tell him the impact of non-immigrant visas on unemployment in the United States. So non-immigrant visas are temporary work visas. The presidential proclamation dealt exclusively with immigrant visas. Those are green card applications and those made outside the country. So the 30 days has come. So what do these reports say? Well, we don't know yet. But Mr. Anderson says they're coming and they looks like they're not going to be good. So what can we see? Well, one of the things as in the presidential proclamation, why it only limited immigrant visas coming into the country, is that the president has authority for immigration into the United States. So that's under the INA, or the Immigration Nationality Act, Section 212F. Right? So will he try to restrict non-immigrant visas coming into the country? So the ones that it looks like he's after are the H-1B, the L-1, and the OPT, which are off of the student visa. So under the H-1B, what are we looking for? Well, one of the things is there is a rule that has been on the table for some time on the H-1B, and it basically says they're going to revise the definition of specialty occupation, definition of the employer-employee relationship, and wages. All right, so with ITServe Alliance, they really kind of hammered immigration on its restrictiveness of what the regulations said. So are they going to try to change the rules of the regulations to do that? Well, maybe. So specialty occupation, we may see a limitation of the types of occupations on there, and the employment relationship. Are we going to see something drafted in there that's going to prohibit or limit the third-party applications, which they said that they wouldn't do, and they'd revise their memo. So that'll be interesting to see whether they do there. But wages, that's one that I think could be very dangerous, and that's what Mr. Anderson says. So he did some analysis. So under the prevailing wage, the way that we as immigration practitioners look into whether or not the jobs that we petition for these visas are going to meet the standards is a website called the FLC Data Center. And when you look at the FLC Data Center, it gives you 4 wages. This is Department of Labor data, right? And it has level 1, 2, 3, and 4. So they're talking about making level 4, which is the highest paid people in the profession, the minimum wage if you're an H-1B applicant, right? Even if it's an entry-level job, first job out of college. Well, what does that mean? Well, here's some examples. For a financial manager in New York City, that would be $254,000 a year. For a biochemist in Chicago, $144,000 a year. And for a computer developer, remember, right out of college, computer developer in Silicon Valley, you would have to make a minimum wage of $172,640. So it's really going to price them out of the marketplace. They're not going to get paid that much, or not very many of them, right? So that's what looks like it may be happening. It hasn't happened yet, but let's see what else. So the L1 also wants to revise specialty occupation, whether or not that's specialized knowledge. What is the specialized knowledge, and what does that mean? So we could see that limiting, what kind of knowledge they have. The employer-employee relationship, which in the L1 is pretty restrictive anyway. So the L1 is for international companies, meaning that they have to have one of 2 types of relationships. One is the subsidiary parent relationship. That's where one company owns another company. The other one is the affiliate, and that's where the same entities have to own the company outside the United States and the company inside the United States in the same interests. right? The same number of people, same interest. So if 3 people own the company in Portugal, for example, the same 3 people have to own it in the United States. If it's only 2 and they want to do another one here, it won't work, right? So, that one's pretty restrictive. And wages aren't even part of the regulation. So put wages into that. And that could happen. So looking at that, that could have a really negative impact on companies that want to invest in the United States. It is a great way for investment money coming into the U.S. And if those companies can't bring their best and brightest people that have worked there, they have to have worked there already a year as a minimum anyway. That could be a big deal. So we'll see if that comes down. Another thing is they want to rescind the H-4 EAD. What does that mean? Well, the H-4 is the visa for spouses of H-1Bs. The EAD, that's an employment authorization document. That's a work card. So if a worker comes over to the United States, their spouse can come and in certain circumstances work. Here's what those circumstances are. In order to get an H-4 EAD, you have to have had a green card I-140 approved already. What that means is it's pretty much a year-long process. I guess you can do premium processing to have that done a little quicker, but you have to have a permanent job in order to do it. Well, why don't they just get green cards then? Well, there's such a backlog for certain countries, including India and China, which are India in particular are the biggest suppliers of tech workers. So they may be on waits for the better part of a decade, and this is to allow while they're on a wait and they have a permanent job offer and an approved visa that their spouses can work. And so it's pretty mean-spirited just to eliminate that second income, especially for techies working in high wealth areas where they have to, support themselves. They also could restrict or eliminate the optional practical training component of the student visa. OPT is what it's called. This is either a 1-year visa-free existence for someone who graduates a U.S. university to go find a job, get in your industry before you file for the H-1B, or a 3-year one if you're in the STEM majors. STEM is science, technology, engineering, and math. So that is really going to be hit universities hard and be a really chilling effect. And we've already seen about a 25% reduction in students from India and China just because of the chilling effect of immigration. You get rid of the OPT, that's going to really slow down. And Canada is smiling all the way to the bank. Their universities are very welcoming. Their industry is very welcoming, and you might see that. So here's a question. Will these executive orders hold up? Rulemaking, right, which is part of regulation changing. So we saw the Trump administration get slammed trying to just interpret, create policy memorandums to interpret regulations, and they just have been nailed time and time again by the courts because they're not following the Agency and Procedures Act. They're just inventing new things, and that's where they've been killed in the court. And this rulemaking comment, which is what you do with, if you want to make a new regulation, you put out some proposed rules, and then you typically have 12 to 18 months of rulemaking on that. Well, that's going to be well past the presidential election. So can they use the COVID-19 pandemic and high unemployment to create the kind of good cause that they need for a temporary final rule, which they've used a lot, and they've used it in immigration. They used it for the H-2B visa for the guest worker program, and the H-2A for agricultural workers, similar type of temporary period. And those are 3 years and 120 days respectively. So they've used it. So wouldn't be surprised if they do it. Or do they care? Do they want to just put it out there, let it get attacked in the courts, use it as red meat if their opponents attack it, say, hey, you're trying to keep Americans from getting jobs and trying to bring in these foreigners. This has been a plank of the Trump administration's campaign policy, and it's definitely part of Stephen Miller's idea to, as he says, turn off the spigot of foreign workers coming into this country. So this is Jon Velie. This is a few of my thoughts on Voice of Immigration. Tune in next time. Appreciate you. We're delivering dreams one visa at a time.